No, I don't. It's not my problem. Mr. Speaker, the House and Committee has moved to call you for a determination on a ruling which I made in relation to two amendments to insert new parts in the name of the Honourable Trevor Mallard. Can I say, Mr. Speaker, that I didn't have time to give this the appropriate amount, or I didn't choose to give it the appropriate amount at the time. For that, I take some responsibility. The debate that the House was having at the time on Part 2, I was trying to determine as a narrow debate around two clauses and was affecting my attention to relevance, and so that distracted me somewhat. We then commenced on to Part 3, and I then gave the matter some further consideration, and in that regard I can understand that the member in whose name the amendments are is a bit perplexed as to why the debate began, and then I subsequently, at the end of his first call, ruled it out. The issue is, in relation to the amendments, whether or not, in my rationale, whether or not they actually are contradicted by something that is in Part 1, or whether they should be associated. I did seek some advice and ruled subsequently, after the debate had begun, that they were out of order because the pertinence of what the amendments contained should be attached to Part 1 and should have been debated at that time, and it's on that basis that I gave my ruling.
Speaking of the point of what the Honourable Trevor Mallard...
And I think there are two parts to it, sir, and I think I thank Eric Roy for his summary, and I don't think, other than the conclusion, I don't think there's any, or the conclusions, I don't think there's any difference on the facts. The first question is whether the committee, having commenced a debate and had a full speech been accepted on a particular part, whether it is within the realms of the chair of the committee at that stage to effectively rule himself out and say that other members don't have an opportunity to debate what had currently had started. But that, sir, I think is probably that's the lesser of the two, although there's an appeal that's going on the others. So the substantive question is whether an additional part can be moved to a bill which puts conditions around what has been agreed to previously by the House, or the House and Committee. There's no doubt, after quite a lot of debate and suggested changes, that that Part 1 had passed, and I think we agree that Part 2 was a fairly minor consequential transitional type arrangement. So I think both of us have been around the House during a period where there has been an increasing use of a part-by-part approach, but I think it's fair to say not quite to the extreme that we've got in this bill, where major legislation with two major areas to do with 90-day legislation and to do with union access are all wrapped up in one part. I think it's fair to say that in the times of Geoffrey Palmer as Attorney General. There would have been quite a few more parts, and even in the time subsequently in the Bolger administration, we would have seen at least 2 parts, one dealing with each of the substantive issues. But what it goes to, Sir, is whether a committee is restricted from putting some conditions to protect workers, in this particular case, on a part which has already been agreed to, saying essentially that the part 1 can work, but as it does work, it should be limited, and that's the essential question. I have been looking. I see that you're looking at standing orders and speakers' rulings. I cannot see something which indicates that cannot happen, sir. And in my view, is that it would be a very large restriction on the right of an opposition party to move amendments which are not unreasonable. I mean, I think there are only 2. And they both certainly go to issues which are pertinent and provide some protections which are pertinent. And, sir, my appeal to you, sir, is that it would be an unreasonable restriction on the rights of the House if opposition members could not move in this form and only be restricted to moving amendments which restrict the approach within one part of a bill.
The Honourable John Carter.
I can just respond to those comments by making these 2 points. One is that obviously I took advice on this issue as well, and what I am told, sir, is that it actually interferes with the fundamental direction of the legislation, particularly relating to Part 1 in previous acts. And as a consequence, the amendment proposed actually does amend Part 1, or would, if it were passed, would amend Part 1 and, of course, the previous acts as well. So that's an important point. The second point is this, sir, that in all the time I've been in the House, that if there is to be an additional amendment, it should be done during that part rather than as an addition to it later on. And I suggest to you, sir, that if we were to allow this to happen, that we would be opening up a whole new way in which we would deal with legislation, that you could pass 1 part or 2 parts or 10 parts and then somebody come up with a new idea and add it in as an addendum to. And quite honestly, I think we would be unwise to go down that path, that the members, if they have a view, should express it at the time that the part is being deliberated on.
Just very briefly.
The Honourable
and there's only, I think, one point that was implicit in what the Honourable John Carter said, that these parts negated parts which had already been passed. That is certainly not the case. They are designed to restrict and to provide conditions on, but not to negate.
I thank honourable members. It's an interesting issue that's arisen, and I'll just seek some further advice myself on the particular matters because I don't want to make any errors on this. But
I mean, I actually wonder, given the time, whether we should seek leave for you to make a considered ruling and, without interrupting urgency, come back at 2:00 for it.
I think that's not necessary. I can quickly consider the information put in front of me by members. Obviously the chairperson is the sole judge of admissibility of an amendment, and that's what Speaker's Ruling 78.1 makes very clear. Now, with respect to a new part, it must be considered in the context of the structure of the bill as it is drafted and before the House. Part 1 deals with amendments to the Principal Act, the Employment Relations Act. It deals with matters contained in the proposed new part. The proposed new part it's argued should have been proposed as amendments to Part 1. And as I understand it, that's what the chair of the committee